Good morning, everyone. We'll start. Whoever wants to join, they'll keep joining. We'll have to complete this today, that's why. So, yesterday we stopped at section number 50. Okay, means 46, 47, 48, 49, 50. They talk about time and place for performance. Basically, it is upon the parties to determine the time and place for performance of the contract. That's what I had told you all. Sometimes it has been left upon the promisee. Sometimes it has just been left upon both of them to decide freely. But they can just do it during the business hours. And sometimes the manner has to be decided. Sometimes even a certain day, proper time, proper place, and everything has to be told that how it has to be performed. So that was about 46 to 50. Go through the illustrations. Now, something we had learned was reciprocal promises. You all even remember we had done in interpretation clause section number 2, which has the definition of reciprocal promise. That is 2F, promises which form the consideration or part of the consideration for each other. You give this in return of this, so reciprocal promise, right? So you have to read 2F with this portion, performance of reciprocal promises. Firstly, promisor is not bound to perform unless reciprocal promisee is ready and willing to perform. When a contract consists of reciprocal promises to be simultaneously performed, to promise and no promiser needs to perform his promise unless and until the promisee is also ready and willing to perform his part of the promise. So there has to be ready and willingness and ability to perform on part of the both the parties. A and B contract that A shall deliver goods to be paid for B on delivery. Yani ki B has to pay them on delivery. A need not deliver the goods unless B is ready and willing to pay for the goods on delivery. Right? दिस इज लाइक अपने घर पे भी कैश ऑन डिलीवरी वाले जो चीज़ें आती है, यू कैन टेक एज अ सिंपल एग्जाम्पल. कुरियर आता है, you had opted for cash on delivery. Unless and until you don't do the cash on delivery, right, uh, it will not be delivered to you. That is a kind of a reciprocal promise only. Section number 52, order of performance of reciprocal promise. So 51 was talking about simultaneous performance. प्रोमिसी पेमेंट करेगा, उससे के बाद ही प्रोमिसर उसको डिलीवर करेगा गुड्स. For 52 talks about order. What is the order of performing? So where the order in which the reciprocal promises are to be performed is expressly fixed by the contract. बताया गया है कि ऐसे ही होना चाहिए, इस तरीके से. They shall be performed in that order. And where the order is not expressly fixed by the contract, they shall be performed in that order according to the nature of the transaction. A and B contract that A shall build a house for B at a fixed price. A promises to build the house must be performed before B is promised to pay for it. It is as per the nature. घर बनेगा, उसके बाद ही तो बी पैसा देगा, उस तरीके से. It depends. It is dependent upon the party. प्रोमिसी बोलेगा नहीं, आप पहले मैं है ना पूरा का पूरा पेमेंट करूंगा, फिर ही आप डिलीवर करना. नहीं तो प्रोमिसर कहेगा कि नहीं, फर्स्ट यू डू द एंटायर पेमेंट, देन ओनली आई विल गो अहेड. सो इट डिपेंड्स अपॉन द नेचर of the transaction, or it depends upon what they have agreed upon, both the parties. So 52 talks about the order. 53 talks about something, some event which is known as a preventing event. So liability of the party preventing the event on which the contract is to take effect. When a contract contains reciprocal promises and one party to the contract prevents the other party from performing his promise, the contract becomes voidable at the option of the party who is so prevented, and he is entitled to compensation from the other party for any kind of loss which he may sustain in the consequence of the non performance of the contract. एक पार्टी तो रेडी एंड विलिंग है, दूसरे पार्टी नहीं कर रहा है. सो जब दूसरा पार्टी नहीं कर रहा है, सो द फर्स्ट पार्टी हु इज रेडी एंड विलिंग, he has the option of making the contract voidable. Right, we learned what is a voidable contract, where at the option of the one party he can bring an end to the contract. Right, so but voidability to hai, but he will also be entitled to compensation. See, A and B contract that B shall execute certain work for A for 1,000 rupees. B is ready and willing to execute the work accordingly, but A prevents him from doing so. The contract is voidable at the option of B. and if he elects to resign it, means he resigns to back off, right, he is entitled to recover from A compensation for any loss which he has occurred due to non performance. ओके 54 वहां पे आप लिख दीजिए डिफॉल्ट इफेक्ट ऑफ डिफॉल्ट as to that promise which should be performed in contract consisting of reciprocal promises. When a contract consists of reciprocal promises such that one of them cannot be performed or that its performance cannot be claimed until and unless the other is performed, means it is dependent on the other promise, right, and the promiser of the promise last mentioned fails to perform it, such promiser cannot claim the performance of the reciprocal promise and must make compensation to the other party to that contract for any loss which such other party may sustain by the non performance of the promise, or sorry, non performance of the contract. Means it that other person has defaulted, उसने नहीं किया, but the contract which has been made between the two parties, it can only come into force unless and until that particular thing is not performed. We'll go through an illustration in this. A hires B ship to take in and convey from Calcutta to Mauritius a cargo to be provided by A. B receiving a certain freight for its conveyance. A does not provide any cargo for the ship, right? A cannot claim the performance of B's promise and must take compensation to B for the loss which B sustains by non-performance of the contract. Okay, so this is very easy. A contracts with B to execute certain builders work for a fixed price. B supplying the scaffolding and the timber necessary for the work. Means A said I will do it, but B has to provide all this. B refuses to furnish any kind of scaffolding or timber and the work cannot be executed. B ने अपना पार्ट तो किया ही नहीं. मीन्स दोनों के बीच ऐसा कॉन्ट्रैक्ट हुआ था कि ए करेगा लेकिन बी को उसके लिए उसको सामान देना पड़ेगा. A need not execute the work and B is now bound to make compensation to A for any kind of loss which is caused to him by the non-performance of the contract. Now, effect of failure to perform at a fixed time in contract in which time is essential, means time is money. So when a party to a contract promises to do certain thing at or before a specified time or certain things at or before specified times and fails to do any such thing at or before the specified time, the contracts or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was that time should be the essence of the contract. मीन्स टाइम उन्होंने डिसाइड किया था कि टाइम सबसे इंपॉर्टेंट है और वो प्रोमिसर ने टाइम को महत्व नहीं दिया एंड नहीं परफॉर्म किया. सो नाउ द प्रोमिसी कैन ही हैज द ऑप्शन टू मेक द कॉन्ट्रैक्ट voidable. इफेक्ट ऑफ सच फेलियर वेयर टाइम इज नॉट एसेंशियल. एक जगह ऊपर वाले पार्ट ए में उन्होंने बोला टाइम इज एसेंशियल, पार्ट बी में कह रहे हैं टाइम इज नॉट एसेंशियल. If it was not the intention of the parties that time should be of the essence of the contract does not become voidable by the failure to do such thing at or before the specific time. But the promisee is entitled to compensation from the promiser for any kind of loss which he has got due to the failure. Okay. Now, effect of acceptance of performance at a time other than what is being agreed upon. You are now accepting it, right? Means you have not there has been a time which has been agreed upon, but even besides that you are accepting it. So if in the case of a contract voidable on account of the promiser's failure to perform his promise which has been at the time agreed upon, the promisee still accepts the performance of such promise at any time other than that agreed. The promisee cannot claim compensation for any loss which has been occasioned by the non-performance of the promise at the time agreed upon, unless at the time of such acceptance he gives notice to the promiser of his intention to do so. Okay. So अगर वो एक्सेप्ट कर लेता है फिर वो ऐसा नहीं कहता है कंपनसेशन दो मुझे, क्यों, तुमने तो एक्सेप्ट कर लिया है, राइट. Go through the illustration. Section number 56 important again, जैसे section number 25 था, this is also very important. Section number 56, which we call it as the doctrine of frustration. Okay, an agreement to do an impossible act in itself avoidable, means sorry, void. An agreement to do an act impossible in itself is void. Contract to do act afterwards becoming impossible or unlawful, or contract to do an act which after the contract is made becomes impossible or by reason of some kind of an event, like for example a war happens. Okay, which the promiser could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. Okay, means when that particular thing becomes unlawful or when that particular thing becomes impossible, that time the agreement becomes void, right? Compensation for loss through non-performance of act known to be impossible or unlawful, where one person has promised to do something which he knew or with the reasonable diligence might have known, at which the promisee did not know, to be impossible or unlawful. Such promiser must make compensation to such promisee for any kind of loss which such promisee sustains through the non-performance of the promise. So there can be some kind of physical impossibility, there can be some kind of changed circumstances, there can be some kind of supervening events. Okay, practical impossibility ho sakti hai. These are all means the subject matter itself got destroyed totally. War ho gaya, ab kya karenge, wahan se maal yahan nahi aa sakta hai, right? So this is known as doctrine of frustration, right? Section number 56 means an agreement to do an act which is impossible in itself is void. So remember this, section 56 says anything happens, impossibility takes place, therefore it becomes void. Reciprocal promises to do things legal and also to do other things illegal means part part है. रेसिप्रोकल प्रॉमिस में कुछ पार्ट हम लीगल करेंगे, कुछ पार्ट इलीगल मीन्स लीगली हम इंडिगो बेचेंगे और इलीगली हम कुछ ओपियम बेचेंगे, ऐसी तरीके से. So where persons reciprocally promise firstly to do certain things which are legal and secondly under specified circumstances to do certain other things which are illegal. The first set of promise is a contract, but the second set is a void agreement. Okay, it means यहाँ पे आप देख लीजिए, A and B agree that A shall sell B a house for 10,000 rupees, but that if B uses it as a gambling house, he shall pay 50,000 rupees for it. The first set of reciprocal promise, namely to sell the house and to pay 10,000 rupees, is a contract, but the second part is for an unlawful object, that is to use it for a gambling purpose. Therefore, that becomes a void agreement. Okay. Now, alternative promise, one branch being illegal. In the case of an alternative promise, one branch of which is illegal and the other is legal, legal branch alone can be enforced. So this is known as doctrine of severability. Severability means you can separate it. जो part legal है आप perform करो, जो illegal है वो नहीं करो. A and B agree that A shall pay B 1,000 rupees, for which B shall afterwards deliver to A either rice or smuggled opium. This is a valid contract to deliver rice, and the void agreement is with respect to opium. Appropriation of payments means किस तरीके से allocation करना, payment allocation. Okay, appropriation of payment means payment allocation. Okay, तो इसमें आप 59 to 61 is entirely for this. It is meant to be applied to several distinct debts. Payment आई मेरे को means and A had to pay to B. Okay, many debts, but now he makes a payment and he says you appropriate it. Means there is A B C D debt. ओके वो बोलेगा कि आप ए में भी थोड़ा अभी काउंट कर ले, बी में भी काउंट कर लो, सी में भी काउंट कर लो, डी में भी काउंट कर लो. ये वो बात है. इट इज मेंट टू बी अप्लाइड टू सेवरल डिस्टिंक्ट डेब्ट्स. द सेम कैन बी अप्लाइड व्हेन देयर इज अ सिंगल डेब्ट एंड द इंटरेस्ट आल्सो देयर ऑन. नाउ 59 is talking about multiple debts. Application of payment where debt to be discharged is indicated, where a debtor owing several distinct debts to one person makes a payment to him either with express intimation or under circumstances implying that the payment is to be applied to the discharge of some particular debt only. The payment, if accepted, must be applied accordingly. Means उसने indicate किया है कि आपको इसी head के ऊपर apply करना है. राइट तो आप उसी के वो ही डेप्ट को आप पूरा करोगे. 60 talks about application of payment where debt to be discharged is not indicated. 59 में बता रहे हैं कि वो डेटर इंडिकेट करता है, यहाँ पे कोई इंडिकेशन नहीं है. whether debtor has omitted to intimate and there are no other circumstances indicated to which the payment is to be applied, the creditor may apply it at his discretion. So now it is at the discretion of the creditor to any lawful debt actually due and payable to him from the debtor, whether its recovery is or is not barred by law and force for the time being, as to the limitation of suit. Just it should not be illegal, right? or void debt. Application of payment when neither party appropriates. When neither party makes any appropriation, the payment shall be applied in the discharge of the debts in order of time, whether they are or are not barred by the law in force for the time being in force as to limitation of suits. If the debts are of equal standing, the payment shall be applied in discharge of each proportionately. Okay. यानी कि इन ऑर्डर ऑफ टाइम बोल रहे हैं, यानी कि जो सबसे पुराना डेप्ट होगा उसके ऊपर एप्लीकेशन करेंगे, फिर उसके बाद थोड़ा कम, फिर थोड़ा कम, नहीं तो सब इक्वली है, 10 के ही है, सपोजिंग आई एम जस्ट गिविंग एन एग्जांपल. ओके, तो आप उनको इक्वली अप्लाई करोगे. नाउ कॉन्ट्रैक्ट्स विच नीड नॉट बी परफॉर्म. कौन से कॉन्ट्रैक्ट्स नेसेसरी नहीं है परफॉर्मेंस के लिए? 62 कहता है इफेक्ट ऑफ नोवेशन, रेसाइशन एंड ऑल्टरेशन ऑफ कॉन्ट्रैक्ट. If the parties to a contract agree to substitute a new contract for it. Novation means substitution of existing contract with a new contract, right? Novation can be something like there is a change in the parties, there is a change in the subject matter, something of that sort. So if the parties to the contract agree to substitute a contract for it, yani ki novation, or to rescind it can be by the parties or it can be by the court's order, or after uh, alter it, right? The original contract need not be performed. Means if there has been a novation, if there has been an alteration, or if there has been a resigned, then जो original contract हुआ था parties के बीच में वो खत्म हो जाता है, और ये जो novation या alteration या resigned की वजह से जो नया contract हुआ है वो perform होगा. 63, it talks about promisee may dispense with or remit performance of promise. Every promisee may dispense with or remit wholly or in part the performance of the promise made to him, or he may extend the time for such performance, or he may accept instead of it any other satisfaction which he thinks fit. So it is upon the promisee in what form he wants to accept the promise. He can remit the whole or the part, he may extend the time, he may take any other satisfaction in place of this particular satisfaction, right? It is upon the promisee. A promises to paint a picture for B afterwards forbids him to do so. Okay, means usko allow nahi karta hai. A is no longer bound to perform the promise, so now he is A is dispensed with the performance. Okay, A owes B 5,000 rupees. A pays to B and B accepts it in satisfaction of the whole debt of 2,000 rupees. Right? Paid at the time and the place at which 5,000 rupees was payable. Thus, whole debt is now discharged. It depends. और ए बोलता है अच्छा कोई बात नहीं, आपने आपने मेरे को 5,000 वो करते थे, ये 2,000 आपके 5,000 से 5,000 जो वो करते थे, आई एम एक्सेप्टिंग दिस एंड दैट. सो नाउ इट इज एंटायरली बीन सेटिस्फाइड. नाउ 64, consequences of rescission of a voidable contract. Rescission means cancellation. When a person at whose option the contract is voidable resigns it, the other party thereto need not perform any promise therein contained in which he is the promiser. Now the party who is rescinding a voidable contract shall, if he has received any kind of benefit thereunder from another party to such contract, restore such benefit so far as may be to the person from whom he has received. Simple as that, right? Means restoration of the benefit to the promiser. Promisee ने resigned कर दिया, cancel कर दिया, so it becomes a voidable contract at the option of the promisee. Now obviously the promiser does not have to perform his part, but whatever any kind of benefit the promisee has obtained, he must return it back to the promiser. So this is known as principle of equity, right? Section number 64. Now section number 65. Obligation of the person who has received advantage under void agreement or a contract that becomes void. Now that was talking, 64 was talking about a voidable contract, but 65, right, talks about a void agreement or a contract that becomes void. और इसमें अगर आपने कोई advantage आपको मिला है तो when an agreement is discovered to be void or when the contract becomes void, any person who has received any kind of advantage under such agreement or such contract is bound to restore it or to make compensation for it to the person from whom he has received. Okay, so यहाँ पे आप restore करोगे या compensation करोगे, और 64 में जो आपको बेनिफिट मिले हैं वो सिर्फ बेनिफिट को आप रीस्टोर कर दोगे वापस. पर 65 में आप रिस्टोर भी करोगे, राइट, as or you will make compensation for it. 65 talks about that. Now 66 talks about mode of communicating or revoking rescission of voidable contract. How you will communicate. The rescission of a voidable contract may be communicated or revoked in the same manner and the subject to the same rule as applicable to the communication or revocation of proposals. जो proposals को लेके जो सारा communication जिस तरीके से आप करते हो वो सारे rules यहाँ पे भी applicable होंगे. Section number 67, it talks about effect of neglect of promisee to afford promiser reasonable facilities for performance. You had to provide the promiser to means some kind of facility so that he could perform the promise, right? But he has not provided. So now what happens? If any promisee neglects or refuses to afford the promiser reasonable facilities for the performance of his promise, the promiser is now excused by such neglect or refusal as to the non-performance caused thereby. इसके साथ आपको सेक्शन नंबर 37 पढ़ना था, मैंने आपको लिखवा भी दिया था वहां पे, राइट, जब हम सेक्शन नंबर 37 पढ़ रहे थे, right? A contracts with B to repair B's house. A neglects or refuses to point out to the to A. B neglects or refuses to point out to A the places in which the house requires repairing. Now A is excused for the non-performance of the contract if it is caused by such neglect or such refusal. Now of certain relations which resemble those created by contract. These are known as quasi contracts. ये section 68 से लेके section number 72 तक ये पूरे के पूरे quasi contracts है, right? So इसमें आप ये जो पोर्शन है चैप्टर नंबर 5 उसके साथ आप दो डॉक्ट्राइन्स याद रखोगे, एक तो क्वांटम मेरिट का और दूसरा है डॉक्ट्राइन ऑफ अनजस्ट एनरिचमेंट, दैट इज नॉट टू एनरिच हिमसेल्फ एट द एक्सपेंस ऑफ द अदर. what is the meaning of quantum merit? It is as much as it is earned. Okay, so these two doctrines you will read with this portions, chapter number 5. Section number 68 कहता है claim for necessaries supplied to persons who are incapable of contracting or on his account. If a person is incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another person with the necessaries which are suited to his condition in life, the person who has furnished such kind of supplies, now he is entitled to be reimbursed from the property of such incapable person, right? In यहाँ पे incapable of entering into the contract इसमें कौन हो सकता है? माइनर हो सकता है, राइट? एंड यहाँ पे दूसरा इन्होंने बताया और एनीवन whom he is legally bound to support, जैसे कि अपना स्पाउस हो सकता है, अपनी फैमिली हो सकती है, राइट? तो फिर क्या होगा? इलस्ट्रेशन देख लेते हैं. A supplies to B who is a lunatic with the necessaries which are suitable for his life. A is now entitled to be reimbursed from B's property. यानी कि या अनसाउंड माइंड पर्सन हुआ या माइनर हुआ या पर्सन टू सम पर्सन्स whom you are legally bound to support. तो ये सिचुएशन में क्या होगा? अगर कोई बंदा आपको नेसेसिटीज देता है, दे आर टॉकिंग अबाउट नेसेसरीज यहाँ पे, राइट? क्लेम फॉर नेसेसरीज विच आर सप्लाइड to a person, not luxuries. They're talking about certain necessaries which a person is supplying to this person. Now what is that person entitled to? Because he has supplied, he is to get reimbursement from the property which belongs to this particular person. Now reimbursement of person paying money due by another in payment of which he is interested. इसका एग्जाम्पल पढ़ेंगे, आपको सब समझ आ जाएगा. A person who is interested in the payment of money which another person is bound by law to pay and who therefore pays, he is entitled to be reimbursed by the other. We'll read the illustration, you will understand. B holds a land in Bengal on a lease which is granted by A, who is the zamindar. The revenue which is payable by A to the government being in arrear, his land is advertised for sale by the government now. Okay? Under the revenue law, the consequence of such a sale will be annulment of B's lease. Now, B, to prevent the sale, and the consequent annulment of his own lease, pays the government the sum due from A. A is bound to make good to B the amount which is so paid. B ने A को लैंड दिया था लीज पे, ओके, बट ये जो लैंड था ना, वो बी का जो लैंड था, ही हैड देयर वाज सर्टेन अरियर्स ऑन हिज पार्ट टुवर्ड्स द गवर्नमेंट. Okay, so what the government does now, he puts that land of A on advertisement to be sold, but now B is interested in that land. So because now that land must be really good, so now what B does, he makes the payment for A कि भाई कोई बात नहीं, मैं तुम्हारे लिए ये भर देता हूँ. तो A agrees, but now B will also be entitled to be reimbursed from A for this particular kind of payment which is done by B. So they have said a person who is interested in the payment of the money which another is bound by law to pay. यहाँ पे A was bound by law to pay to the government, but that particular person A जो है, he is interested in that particular property, so he has made the payment. So that is why now what will happen, जो particular person who was bound by law to make the payment, he will repay to B. Obligation of person who is enjoying the benefit of a non-gratuitous act. Non-gratuitous act means something which is done voluntarily, right? Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing which has been so done or so delivered. A, who is a tradesman, leaves goods at B's house by mistake. It was a non-gratuitous act. He did not do it out of gratuitousness. Okay, he did it by mistake. Now B treats the goods as his own. ऐसा थोड़ा है भाई, वो तो गलती से वहां पे रख के चला गया था. Now, but B has to give it back. So now he is bound to pay A for them. You enjoyed it, no? You had the benefits out of it. 71 talks about responsibility of the finder of good. A person who finds the goods belonging to another person and takes them into his custody is subject to the same responsibility as a bailee. जब हम bailment पढ़ेंगे तो हम इसका आप ये सेक्शन नंबर 71 आप समझ जाओगे. जो फाइंडर ऑफ गुड होता है ना, क्या होता है, मीन्स जब उसको जब गुड्स मिलते हैं तो वो उसका ध्यान रखता है, केयर करता है, ही मेक्स एक्सपेंसेस बेसिकली, देन ही गोज एंड रिटर्न्स इट टू द रियल ओनर. So now obviously because he has done it, he needs to be repaid, he needs to be reimbursed for what any kind of care he has taken for that particular goods. 72 liability of person to whom money is paid or things have been delivered by mistake or under coercion. A person to whom money has been paid on anything delivered by mistake or under coercion, he must repay it or he must return it, means return that particular thing. A and B jointly owe 1000 rupees to C. A alone pays the amount to C, and B, not knowing this fact, pays 100 rupees over again also to C. Now C is bound to repay the amount to B. Okay. A railway company refuses to deliver up certain goods to the consignee except upon the payment of an illegal charge for the carriage. The consignee pays the same sum charge in order to obtain the goods. He is entitled to recover so much of the charge as well as the illegal one and excessive one, right? Because that was done by coercion, right? So B may it was got by coercion, A may it had happened by mistake, right? So this is what they are saying. 72 talks about liability of person to whom money is being paid or a thing is delivered by mistake or by coercion. So ऐसी कोई चीज होती है तो आपको वापस रिटर्न करना होता है. नाउ ये जो है 73 में और 73 में बहुत सारे इलस्ट्रेशंस हैं. आप आराम से पढ़िएगा और एक बुक लेना जहाँ पे वो लोग कहते हैं ना ए से बी, तो आप एरोज लगा के आप समझ के करिएगा, राइट? ये 73 जो ये चैप्टर है, चैप्टर नंबर 6, राइट? It talks about basically remedies of the consequences of breach of contract. Okay, what are the consequences? पर यहाँ पे आप लिख दीजिए रेमेडीज ऊपर. So 73 talks about compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from party who has broken the contract compensation for any loss or damage which is caused to him, thereby which naturally arose in the usual course of things from such breach, or which the parties knew when they had made the contract to be likely to result from such breach. Such compensation is not to be given for any remote or indirect loss or damage which is sustained by reason of the breach. Means the breach जो होना चाहिए, right? यानी कि जो damage होना चाहिए, it must be direct. It cannot be indirect. That's what they are saying. Now, part B talks about compensation for failure to discharge obligation resembling those which are created by contract. So यहाँ पे क्या है? Quasi contract की बात कर रहे हैं. When an obligation resembling those which are created by contract has been incurred and has not been discharged, any person injured by the failure to the discharge, it is entitled to receive same compensation from the party in default as if such person had contracted to discharge it and had broken his contract. So यहाँ पे resemblance will also be considered to be a contract. Explanation क्या कहता है? In estimating the loss or damage arising from the breach of contract, the means which existed, right, of remedying the inconvenience caused by the non-performance of the contract must be taken into consideration, right? So what they are saying is any kind of loss or damage which happens out of a contract which had been agreed upon or out of a relationship which resembles a contract, that is a quasi contract. तो ये situation में क्या होगा? Because that other party did not perform, so some kind of a loss or damage had been caused to this party. So this particular party now is eligible to be compensated. That is what section number 73 talks about. Compensation for loss or damage caused by breach of contract. Okay. इसमें देखो कितने हैं, ए से लेके आर तक आपके वो है illustrations है. They are quite lengthy. Just go through them once. Okay. एक बार देख लीजिएगा. कभी कभी क्या होता है, ये एविडेंस एक्ट और कॉन्ट्रैक्ट एक्ट से है ना, illustrations भी वो लोग डायरेक्ट डाल देते हैं और फिर what they do is they'll put the illustration and they'll ask with which particular thing this is relating. So if you go through these illustrations, you will get to know it talks about compensation due to loss or damage. You will have to go through it again and again, then only you will get it. Okay, they are quite lengthy though. Just go through them. 74, compensation for breach of contract where penalty stipulated for, right? So इसमें क्या है? When a contract has been broken, if a sum is named in the contract, यानी कि सम इज प्री एस्टिमेटेड, यानी कि ऑलरेडी कॉन्ट्रैक्ट में लिखा गया है. यहाँ पे जो लिखा है ना, सम इज नेम्ड इन द कॉन्ट्रैक्ट, आप वहां पे लिख दीजिएगा प्री एस्टिमेटेड. वो चीज को एंटायरली लाइन अंडरलाइन कर दीजिएगा. सम इज नेम्ड इन द कॉन्ट्रैक्ट, इट मीन्स प्री एस्टिमेटेड बट इट हैज टू बी जेन्युइन, राइट? So sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any other stipulation by way of penalty. So either sum is named in the contract or a stipulation by way of penalty, right? The party complaining of the breach is entitled, whether or not actual damage or actual loss is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be, penalty which has been stipulated for, right? So there has been the party complains of it. So यहाँ पे क्या होगा, अगर कोई पेनल्टी स्टिपुलेटेड है या ऑलरेडी कोई अमाउंट मेंशन किया गया है कॉन्ट्रैक्ट में, राइट? सो द पार्टी हैज टू रिसीव इट. एक्सप्लेनेशन, a stipulation for increased interest from the date of default may be stipulation by way of penalty. ये explanation जो दिखा है ना, उसके साथ आप illustration D पढ़ना. A gives B a bond for repayment of rupees 1000 with interest at 12% at the end of 6 months, with a stipulation that in case of default, interest shall be payable at the rate of 75%. So what they're saying, a stipulation for an increased rate from the date of default also becomes a stipulation by way of penalty. right? So from the date of default, this is a stipulation by way of penalty, and B is only entitled to recover from A such compensation as the court considers to be reasonable. Exception क्या कहता है? When any person enters into a bail bond, recognizance, or any other instrument of the same nature, or under the provisions of any law, or under the orders of the central government or of any state government, gives any bond for the performance of any public duty or act in, in which the public is interested, he shall be liable upon the breach of the condition of any such instrument to pay the whole sum which is being mentioned therein. इसके साथ आप पढ़िएगा, टू पे द होल सम को हाईलाइट करके आप इलस्ट्रेशन सी पढ़िए इसके साथ। ए गिव्स अ रिकॉग्निजेंस, इट्स लाइक अ बेल बॉन्ड, बाइंडिंग हिम इन अ पेनल्टी ऑफ ₹500 टू अपीयर इन कोर्ट ऑन अ सर्टेन डे. He forfeits his recognizance. Now he is liable to pay the entire penalty. Explanation. A person who enters into a contract with a government does not necessarily thereby undertake any public duty or promise to do an act in which the public is being interested. Okay, go through these all illustrations once, you will get it. 75, party rightfully rescinding a contract, he is entitled to compensation. Means who is rightfully rescinding, यानी कि cancelling. So a party who rightfully resigns a contract, he is entitled to compensation for any damage which he has sustained through the non-fulfillment of the contract. Okay, so now we'll just stop over here. Tomorrow I'll just go through this indemnity, guarantee, bailment and agency फटाफट उसमें क्या क्या important है मैं बता दूंगी. This chapter number 6 जो था, consequences of breach of contract, again I'm repeating, they are the remedies which are stated over here due to the breach of contract. Generally they have said compensation diya jayega, right? Section 73 also talks about that. 74 also is talking about that only, in a way, that is stipulation by way of penalty, या कोई अगर प्री एस्टिमेटेड अमाउंट ऑलरेडी मेंशन किया गया है कॉन्ट्रैक्ट में तो पार्टी हैज टू पे दैट. एंड 75 ऑल्सो टॉक्स अबाउट अगर कोई पार्टी राइटफुली यानी कि लीगली वो कॉन्ट्रैक्ट को कैंसल करती है तो वो भी कॉम्पनसेशन के लिए हकदार है. सो दिस इज इट विद कॉन्ट्रैक्ट एक्ट. अगर वो लोग क्वेश्चन पूछेंगे तो ये 1 से लेके 75 तक ही ज्यादातर आएंगे. सो 1 से 75 लेके तक आपको अच्छे से एकदम करने हैं. उसके बाद के जो सारे हैं ये इंडेमनिटी, गारंटी, बेलमेंट, एजेंसी, उसमें क्या क्या इंपॉर्टेंट है मैं फटाफट आपको कल. ओके, थैंक यू.